Chapter 2, Testamentary Succession. Section 1, Wills. Subsection 1, Wills in general. Article 783. A will is an act whereby a person is permitted, with the formalities prescribed by law, to control to a certain degree the disposition of his estate to take effect after his death. Article 784. The making of a will is a strictly personal act. It cannot be left in whole or in part to the discretion of a third person, or accomplished through the instrumentality of an agent or attorney. Article 785. The duration or efficacy of the designation of heirs, devasees or legatees, or the determination of the portions which they are to take, when referred to by name, cannot be left to the discretion of a third person. Article 786. The testator may entrust to a third person the distribution of specific property or sums of money that he may leave in general to specified classes or causes, and also the designation of the persons, institutions, or establishments to which such property or sums of money are to be given or applied. Article 787. The testator may not make a testamentary disposition in such manner that another person has to determine whether or not it is to be operative. Article 788. If a testamentary disposition admits of different interpretations, in case of doubt, that interpretation by which the disposition is to be operative shall be preferred. Article 789. When there is an imperfect description, or when no person or property exactly answers the description, mistakes and omissions must be corrected. If the error appears from the context of the will, or from extrinsic evidence, excluding the oral declarations of the testator as to his intention, and when an uncertainty arises upon the face of the will as to the application of any of its provisions, the testator's intention is to be ascertained from the words of the will, taking into consideration the circumstances under which it was made, excluding such oral declarations. Article 790. The words of a will are to be taken in their ordinary and grammatical sense, unless a clear intention to use them in another sense can be gathered, and that other can be ascertained. Technical words in a will are to be taken in their technical sense, unless the context clearly indicates a contrary intention, or unless it satisfactorily appears that the will was drawn solely by the testator, and that he was unacquainted with such technical sense. Article 791. The words of a will are to receive an interpretation which will give to every expression some effect, rather than one which will render any of the expressions inoperative, and of two modes of interpreting a will, that is to be preferred which will prevent intestacy. Article 792. The invalidity of one of several dispositions contained in a will does not result in the invalidity of the other dispositions, unless it is to be presumed that the testator would not have made such other dispositions if the first invalid disposition had not been made. Article 793. Property acquired after the making of a will shall only pass thereby, as if the testator had possessed it at the time of making the will, should it expressly appear by the will that such was his intention. Article 794. Every device or legacy shall convey all the interest which the testator could devise or bequeath in the property disposed of, unless it clearly appears from the will that he intended to convey a less interest. Article 795. The validity of a will as to its form depends upon the observance of the law in force at the time it is made.